Cully, welcome to Constituting America's Constitutional Chats podcast. We'd love for you to share some opening comments on our topic today, and then we'll go to questions.
Well, Kathy and Janine and gang, great to be back with you. I did retire from the Navy in 2022, so you can update my bio. 30 years was plenty of time, and I'm done. So I'm happily retired from the Navy. You've asked me to speak about the Supreme Court's recent decision style Trump against United States, which was handed down on the last day of the term. And I'm going to spend about 7.5 minutes with you sort of discussing the broad outlines of the holding. This case, like all cases in controversy, came about because the president, as you know, was indicted by the feds for conduct alleged to involve official acts during his tenure in office surrounding January the 6th in the events run up to it. And those indictments fell into five big buckets. And I want to lay them out quickly and then talk about the holding so you understand it. First, the first set of indictments was his activities to try to change the electoral vote. Second was his activities, if any, related to organizing fraudulent slate of electors, according to the indictment. The third was discussions he had with DOJ, the Department of Justice, to try to get them to investigate allegations of fraud. The fourth was to coerce or persuade the vice president to change the electoral count on the day of the electoral count. And the sixth was by exploiting or disrupting the events leading up to January 6th from his public comments and social media presence. Now, the court, in a 6-3 decision by the Chief Justice, held that presidents enjoy absolute immunity for actions taken within their, quote, conclusive and preclusive sphere of authority granted to the office by the Constitution. Next, the presidents enjoy at least presumptive immunity or a presumption of immunity for all other official acts. The majority opinion did say that presidents are not above the law and that all parties agree that no president enjoys any immunity at all for their personal acts. The opinion, this is key for you folks to understand. This didn't end the case, all right? I think a lot of people think this is just one and done and it's over. But the chief made clear that at the current stage of the proceedings in this case, the court did not need to decide whether that immunity must be absolute or instead whether a presumption of immunity is sufficient, because the Supreme Court is a court of last resort. The court does not find facts. And the court made clear that Roberts explained that in determining whether there is immunity, quote, the first step is to distinguish a president's official from unofficial actions, unquote. And so he made clear that in this case, quote, and this is key, no court has thus far considered how to draw that distinction in general or with respect to the conduct alleged in particular, unquote. And he stressed that's likely because, quote, despite the unprecedented nature of this case and the very significant constitutional questions it raises, the lower courts rendered their decisions on a highly expedited basis, unquote. So this now goes back to the district court, which is charged with then on an allegation by allegation, act by act, trying to decide whether which bucket it falls under. Does it fall under the absolute immunity bucket or conclusive and preclusive? And you'd be like, you know, you guys know from Constituting America, pardon is pure power that the president enjoys. There are other actions that are official acts where the presumption of immunity applies, where, for example, they're doing something with the legislative branch. And then there's personal acts which enjoy no immunity. As a result, the Supreme Court, got rid of, it's called vacated, the lower court's judgment and remanded or sent back for further fact-finding consistent with the opinion. But before doing so, it said, in doing so, it offered some guidance. And this is the last bit I want to end with in my last 3.5 minutes. Proclaiming that, quote, Trump is absolutely immune for prosecution for the alleged conduct involving his discussions with the Justice Department officials, reminding people that ultimately it's that because the Justice Department is part of the executive branch, and of course the president's going to have discussions with the Justice Department, he's absolutely immune for that. With respect to the second tier, the presumption of immunity, the court said that it's ultimately the government's burden to rebut the presumption of immunity for other claims, such as those involving his conversations with the vice president about the electoral certification process. Two other tidbits here. And I hope during the Q&A you guys tee this up because I love hard questions. This is going to affect all the four cases he's been involved in. The New York case, the Atlanta case, the federal classified documents case, and then of course the J6 case. The court said that, and let me get the language so you understand it, that any court looking at this may not look into the president's motive, so they can introduce no evidence of the person's motive. And secondly, quote, testimony or private record of the president or his advisors probing such conduct may not be admitted as evidence at trial. So think about the New York case brought by Alvin Bragg. You had Hope Hicks testifying. You had texts. You had all sorts of information that were from him, his records, or his advisors that were admitted at trial, which the jury had to take under consideration when they rendered their verdict. Think about for example, January 6th prosecution, which hasn't taken place yet, but that's going to limit what the federal prosecutors can put in. Think about the Atlanta case, right, that Fannie Willis and her office brought in state court. They relied on all sorts of conversations that the president, because remember he was the president until January 20th, was having with, and his Justice Department was having with Georgia officials. And so it's going to take a long time to unwind and understand and then apply the court's guidance in this decision. And the last thing I'll leave you with in the final 45 seconds I have before I get the hook is, if you like Trump, you're going to like this decision. If you don't like Trump, you're not going to like this decision. But I would ask you to erase the chalkboard for a second, which I know you guys do a very good job of. And think about it in terms of the office of the presidency and what this does and does not do for future presidents 10, 15, 20, 50, 100 years from now. Because you don't want your president, whoever she or he is, second guessing the decisions she or he is having or conversations she is having with administration officials and others because they're worried about being prosecuted for something that falls into the absolute immunity bucket or the presumption of immunity bucket. So I think to many of us who are not political, we're more nerds and scholars, we look at this from that perspective, and I would encourage you to do the same as young professionals. So I'll turn it over to you guys.
Well, thank you, Cully. That was a great explanation, and it has been a little confusing for me at least. And you cleared up a lot with explaining how it's going to go back to the lower courts in some cases and what they decided and what they didn't decide. But Janine, I'm going to turn it over to you.
Okay. Hello. And I'm thrilled to be having this discussion with you. All right. So here's my first question for you. There's immunity and there's executive privilege, and then there's what's in the Constitution. And in Article 1, Section 6, which I sent to Kathy and Lacey, so this can maybe be put up in the screen on the screen. I've always been fascinated with this particular section of the Constitution, Article 1, Section 6 clause. They shall in all cases, except treason, felony, and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from the same, and for any speech or debate in either house, they shall not be questioned in any other place. So I think this is really interesting because my understanding of this over the past 14 years, as founder and with this foundation about the United States Constitution is that our representatives, the Senate, the House, the president, they need to be able to feel that when they're in office, they can govern and speak freely and speak their minds and make decisions that may or may not be popular. Because in the olden days, in the House of Burgesses and whatnot that were in our colonies in the beginning, if someone said something they didn't like, the king didn't like, he would just throw out the whole Congress, or they would walk in and just arrest people and censor them and put them in prison because they said something that the king or somebody didn't like. So I believe that this stemmed from that they really felt it was important that our representatives, whoever they may be, have the freedom to speak their minds and to actually govern while they're in office. And this is the actual clause in the Constitution that talks about that. So I wanted to know what your thoughts are, how this correlates with all these particular cases, because there's this mantra out there that this was just made up, and that suddenly the president's going to do anything or he wants to do, any president. But we have checks and balances also. I would love to talk to you about that would prevent a kind of tyrant, a tyranny from raising its head. And there's all this hysteria out there that suddenly, the president, whomever it may be, is going to be able to do A, B, C, and D, and they'll be immune from it. But that's really not. I don't think what any of this is saying or where this is coming from. So, can you put this in kind of context for us?
Yeah, appreciate the question, Janine, and I hope you feel better. Miss seeing your beautiful face. So remember, three co-equal branches of government laid out in the federal Constitution. Article 1 is the legislative branch, Article 2 is the executive branch, Article 3 is the judicial branch, headed by a Supreme Court. And so in referencing Article 1, if you could put that back up, Lacey, you'll see that falls squarely in Article 1, which deals with the legislative branch. And doesn't say all senators and representatives are above the law. And this is commonly referred to as the speech and debate clause. And it's been narrowly interpreted at first, and now it's been somewhat more broadly interpreted. But it basically means that if you're on the House or Senate floor and you're speechifying, and we know now because of C-SPAN, they do a lot of speechifying, that they can pretty much say whatever they want. Senator Turner can say, hey, Senator Stimson is a dummy. No one can do anything about it. You can say, the state of Alaska is not my favorite state. It's too cold, and the state of Florida is too hot, and it's just right in Ohio. You can say whatever you want because we want to give a form of protection beyond what the First Amendment allows for. And remember, the Bill of Rights came after the Constitution. The original Bill of Rights did. 2 senators and representatives, all now 535 of them. This is distinct and different from the fact that we have one commander-in-chief, which falls under Article 2. You can take that down now, Lacey. And that is Article 2, Section 1, Clause 1, which is the executive power will be housed in a president of these United States. And so to your point about this has been interpreted by some to give a broad, almost lawless grant of authority to any president in the future, God forbid President Trump, term 2, to just sending SEAL Team 6 to kill people, his political opponents, and that sort of thing. I just don't think that holds any water because, number one, the Supreme Court's majority opinion says, number one, the president's not above the law. Number two, they reference the Nixon versus Fitzgerald decision, which was from years ago when you and I, Kathy, were just coming up in the ranks. And that held that the president is not immune from civil suits and civil liability for money damages. And so the court did have precedent and cited precedent in this decision. This was in the criminal law context, but the theory is the same thing, that presidents enjoy immunity, absolute immunity for their plenary authority. They have a presumption of immunity in actions that fall broadly under the category of being the commander-in-chief and the chief law enforcement officer, but the government can prosecute them if they can rebut that presumption, and they have zero immunity for their personal acts. And so this is an extension of Nixon versus Fitzgerald, but in the criminal law context, and lays out for the future whatever President Biden and then his successors are going to live under. As to the SEAL Team 6 comment, I was a JAG. I deployed with the Navy SEALs as the Navy Special Operations JAG. I can tell you right now that there's no JAG I know that if the order came from the president to kill your political opponent and they sent it to SEAL Team 6, the JAG and the SEALs themselves would say, absolutely not, we're not doing that. And it is not a violation of the Uniform Code of Military Justice to disobey unlawful order. In fact, they would not obey it. So that's not going to happen.
Okay, couple of questions. Obviously, I know Article 1 is the Congress and Article 2 is the executive, but I just didn't know if it was the same kind of concept that the president needs to be able to govern under, with some sort of protection. But just generally the same concept. And since that can't be the exact clause, the Supreme Court they base everything primarily on the Constitution. So where in the Constitution then, in Article 2, do they get, what are they basing this decision on, that the president has the right? Because I just was always fascinated with that Article 1 section, but I felt that it just kind of applied generally to kind of what they're trying to say. But what are they referencing in the Constitution, or is it only another precedent of another decision that the president has immunity? And the second question is, define the difference between, say, immunity, civil immunity for acts as president. What would be an example of something that would be civilly that he did that wouldn't be protected while in office? And what's the difference between immunity and executive privilege?
Now, let me answer those questions in reverse order. We don't have to think of a hypothetical for civil immunity for personal acts, because we have the Clinton Paula Jones case where Bill Clinton sexually harassed Paula Jones, and the court found that he was not immune from his personal acts in that sexual harassment. He paid out a civil fine for that. And so he was held civilly liable. Civil means money.
Was that done while he was in office, though? Was that done while he was in office with Paula Jones?
It was
done earlier.
It was done before, but he was sued when he was in office, and that suit was allowed to proceed while the president. Whereas the Office of Legal Counsel, the lawyers within the Justice Department that interpret all federal laws on behalf of the government, have legal counsel memos that say that presidents themselves cannot be prosecuted criminally while they're in office. And so you toll the statute of limitations, but you can rebring those criminal charges after they're out of office. And that's, of course, what happened here. Former President Trump was criminally prosecuted in four different jurisdictions. And so let me go to the core of your first part of your question, and that is, understand that under the speech and debate clause under Article 1, that's a prophylactic. Okay, that is a limited form of protection for speech for members of the Senate and the House when they're on the floor of that representative body. If they go out to M Street here in Washington, D.C. or somewhere else, they no longer enjoy the protections of the speech and debate clause. So they don't have the same broad authority that B1 Commander-in-Chief has. So you're right to point out, Janine, that the decision in the majority or the dissent did not point to, oh, look at, Article 2, Section 1, Clause, blah, 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 to say that's where they found the word immunity. They talked more broadly about the unique position that the President of the United States has, not only as the Commander-in-Chief, but also the Chief Executive Officer of the United States and the Chief Diplomat for the United States, and why in all of those three and other jobs that they have under one hat, they have to have immunity from prosecution for their core presidential authority, and a presumption of immunity for their powers that are not conclusive and preclusive. What does that mean? Preclusive and conclusive. Precluded and and cabin in the office of the president. So like one example that they use, and I could use it too, is pardon power. If you're the president and I'm your son and I'm a knucklehead and I've been doing all sorts of stuff and I got, federally prosecuted for something, as the president, you could pardon me. And Senator Gilbert and Senator Hensley and Senator Katchester can say, hey, President Turner, she's bad, boo-hoo-hoo, get her out of office. You have plenary authority. That's a core presidential power, is the pardon power. There are other powers that the president have that's exclusive to the president, but also done in cahoots with other branches of the government. I think it's required reading, honestly, for your folks to read the section of the opinion about the role of the vice president. And here it was about Vice President Pence, because remember, Vice President Pence is the number two. Any vice president is the number two in the executive branch. But they're also the president of the Senate. And so, for example, when they're up on the Hill pushing the president's agenda, they're exercising Article 2 power. When they're presiding over the Senate on behalf of the administration, they're arguably exercising Article 2 power. When they're casting a tie-breaking vote, they're exercising Article 2 power. When they're there to push forward something else, they may be operating just as a quasi-legislative branch. And so I think it's a really interesting history lesson for anybody, lawyers and everyone else, to read that part of the opinion, because that's why they sent it back to the prosecutor to find out about the conversations and communications between Pence and Trump, and to see whether the government could overcome the presumption of immunity, because Pence, for example, was occupying a legislative role versus an executive branch role. So the main takeaway I think people should have on this opinion, among others, is this did not end the issue. This sent, except for the communications between DOJ, this entire case goes back to the district court judge, who does what trial judges do: slowly, methodically, laboriously, boringly, put witnesses in front of the court, look at documents, look at text, look at all the other evidence, and decide on it evidence by evidence, chunk by chunk, Lego piece by Lego piece, whether there's absolute immunity, presumption of immunity, whether the government's overcome the presumption of immunity, or whether it's a personal act. If it's a personal act, boom, they can go forward. And there are things in several of these charges that were personal in nature. And Trump's lawyer at the oral argument actually conceded that when Amy Coney Barrett was questioning him. So something's going to remain on these charge sheets.
All right. Well, I have to pass, but this is all very, very interesting. So in conclusion, like for a 15-second answer, because I don't want to take up any more of Jules' time. Immunity, it gives him immunity. This decision gives the president immunity for what? You said it, but just to recap it again and to make it really quick, like 10 seconds.
Absolute immunity for conclusive and preclusive presidential official acts. A presumption of immunity
in the White House or outside of the White House, both.
Yeah, that's a perfect question. This is not like a speech and debate clause where the only place they get to have it is on the floor of the House or the Senate. This is the president gets to roam about and do whatever he wants as long as he's in the office of it. He occupies the office of the president, not the physical location, but the robe of the office of the presidency.
Okay. Mm-hmm.
All right, Jewel, stump the
And there's
chart.
a presumption. All right. Thank you very much.
This is a topic that, because it's been in the news, so many of us have heard. And I wanted to start with somewhat of an observation that, as a lawyer, you may hate, but we live in a trust society, and a society where a man's given rights, and then we establish a government which we try to give limited rights, and we allow our rights, then man's rights, to be infringed upon in the most limited manner possible to ensure everyone's safety. And in a society that's going to be built like that, there is never going to be a law for everything, because it's simply not necessarily possible, which means that some of our law is, as we've talked about on the show before, sometimes our rulings on law come down to claims of common law or natural law precedent, which has been more or less somewhat stretched and put and a premise that's been not discussed on the surface as much in recent legal scholarly work and in law schools and other places and in the courtroom. It's not directly referenced as commonly. So that leaves us with very confusing situations like this, where we're discussing something where we have an individual's rights and the president of the United States. He's still a person, but we're talking about him as the president in an office. And we're trying to get down to nitty gritty of a question of him performing an act and trying to define if it is an act of the office of the president or an individual, and which of those would be wrong. And I guess what I'm going to ask you then, with that as the background to my question, is if a president believed that there was an unlawful election, then within the president's rights, what would the president then be able to do? And honestly, many of us may not like what the answer is, because either way, you're going to be on one side or the other. And if there was ever an unlawful election, what is the president's duties as as still current president of the United States, who would have lost an unlawful election?
So if I was still a judge wearing my black robe, Jewel, I would sustain the objection to your compound question, which is like 12 questions. But since you're a normal guy and I like you, I'll try to peel out what the real questions I think are, because you always make great points. Let me start with sort of a fundamental observation about something you said in the beginning. And I want to make sure you and I are on the same page on this. And that is, you said, man is given rights. And some people would say, no, man is endowed with inalienable rights, and man grants to the government only those powers that are enumerated and written, and then he or she enjoys all the rest of the rights, natural or otherwise, that he's endowed with. I think you would agree with that, just because I've had many chats with you over the years, but I want to make sure the folks that are listening understand that I think we're both saying the same thing, right?
Yes, 100%.
Okay. So I think also the hard part about this is, just like everybody in the country had an opinion about Hillary Clinton, one way or the other. Everybody in the country, even my Labrador retrievers, have an opinion about Donald Trump. Okay. I mean, they either like him or they don't like him. All right. What is harder to do is to divorce yourself from the name of the person, Trump, and think about this opinion as an American who loves the Constitution, who wants the president to enjoy and have the authority granted to her or him in the Constitution, not an inch more, and the authority granted to the members of the House and Senate, and not an inch more, and the judicial power invested in a Supreme Court and lower federal courts that the Constitution, that the Congress may create. And so as the chief law enforcement officer of the United States, and when you mean chief law enforcement officer, I don't mean, the Constitution doesn't mean of everybody in every state. What they mean is the federal law of these states. Remember, if you think about criminal law, Jewel, there's 2,300 elected DAs around the country, across 3,143 counties, across 50 states. 90% of criminal cases are prosecuted at the state and local level. only 10% are prosecuted at the federal level. There's 94 U.S. attorneys around the country. They all report to the Attorney General of the United States, who's the chief federal law enforcement officer of the United States. And the president, of course, sits above him as the chief law enforcement officer of the United States. And so if, for example, in a federal election, there are claims or allegations of election fraud, and that's gone back to way before you and I were born, way before you and I were born, and I'm 60. Of course, the President of the United States, through the Justice Department, through normal channels, should investigate that. The Trump Justice Department investigated that and found that there were no credible allegations of election fraud, and Trump believed differently. He didn't listen to Bill Barr and others in the Justice Department. Said, Mr. President, look, we looked into this. There's just no allegations of credible allegations of election fraud. We looked at it in Pennsylvania. We looked at it in Georgia. We looked at it elsewhere, Wisconsin, et cetera. And there's this no there. That doesn't prevent a president, whether it's Trump, bump, or dump, set the name aside, from, if they believe, based on other information they have, that there were election irregularities, from questioning or pushing the Justice Department to look harder. That is not illegal. Other candidates for the presidency, I can think of Hillary Clinton, among others, that come recently to mind. Of course, she wasn't the president, have alleged election irregularities at the federal level when they were running for office. We want people, set aside, get rid of the name Clinton, get rid of the name Trump, get rid of the name of any president you've ever heard of, and let's just call it President Labrador Retriever. Okay. Candidate Retriever has a First Amendment right. If he's the president, he's the chief law enforcement officer. If he's just a senator or congressman or a regular citizen, he has a First Amendment right to protest grievances against the government and also claim that there was election fraud. Al Gore, who was the sitting vice president of the United States, claimed that there was election fraud in Florida, that the ballots in Chad's, those punch hole ticket ballots were irregular, and that he actually won, not George W. Bush. In 1960, in Hawaii, Nixon claimed that there were irregularities and that he won Hawaii, not Kennedy. So there's a long list of instances where candidates, either the president, the vice president, the senator, or other person, citizen, were claiming irregularities. So what you do not want to do, if you think about it, if you were one of the founding fathers, because you got the hair, you look good, right? And you got the whole look, is you don't want to defenestrate the president as the chief law enforcement officer of the United States. You want to empower the office of the chief executive to do that. Now, I live on Earth too, and I understand people have very strong feelings about President Trump's demeanor, his actions, his tweets, and all the rest of it. And I think that beclouds a lot of people's ability to think through this from a Constituting America perspective, because we have our political hat and we're all on the ground and we get our Twitter feed and we hear stuff in social media. And so we're sort of impacted by that. Does that help sort of answer your question?
Yeah, definitely. I think that it would make almost another observation for ourselves as we challenge, our audience, is that we do have to come to grips with the fact that most people in Constituting America want a constitutionally regulated government. And everything you said about where our rights come from, of course, we believe that what our founding documents say, and we want a government that follows the law of those documents. And we have a lot of shows about all the ways that our government, it's still the most amazing country that's been created in the history of mankind, but a lot of ways that our government currently is violating those principles consistently, grossly. And while that may be true, we do have to come to grips with the presidential role. There are powers that the president may have and actions that the president can take that we may not like. And if we don't want the president to be able to do those things, then there are places in the Constitution that we'd have to consider an amendment, and we'd have to come to grips with what a more limited executive would look like and what that would be. Because the same way that there is intel on a terrorist leader that may be wrong, and the president chooses to take that strike. And then you can go back and say, well, how good was that intel? What about this other intel that said that he wasn't there? What about the intel that said his family was there and you still chose to do the strike? And there's many cases we could go through that don't have to do with like a terrorist drone strike in the same situation. You know, what are the powers of the executive? Our founders wanted them limited, but they wanted them strong enough to make the country work. And there may be things that we don't like that the president can do if we are going to follow that model. And if we don't want to follow that model anymore, then someone's got to come up with some better model that they want to follow and what that would really look like of a weaker executive branch. And this is not even getting into the administrative state. This is just about the president himself.
Yeah, and I mean, to your point, and I know Lacey gave you the hook, so I'll answer quickly. This is why the Articles of Incorporation failed, right? The Articles of Confederation failed, and I know Constituting America has done a really nice job on that program, series of programs. And they didn't want a king, but they also wanted to invest all the executive power in one president of the United States. And so that's left for another day, but we'll move on to the next question.
Okay, and Jewel, I think your time is up and we're going to go to Wyatt.
All righty. Thank you so much. Well, first, I just want to thank you for your service in the Navy. That is something that's very important, and I just really want to thank you for that. My first question, so because the Supreme Court blocked prosecutors from inquiring the president's motive when doing some unofficial or official acts, do you believe that it will make it more difficult to determine which role the president was acting in as president or whether it's for personal gains?
No, and here's why. And this has nothing to do with this case, Wyatt. It's a great question. I think some folks, our heads have exploded when they read that and they thought, oh, well, that's the end of it. This whole thing is a sham. The Supreme Court's in bed with the president. This is ridiculous. Motive is never, let me repeat, motive is never an element of a crime. Ever. I prosecuted homicides, rapes, child sexual abuse, drugs, burglaries, robberies. It is never an element of a crime. Yes, we're human. Yes, we want to know, well, why did that guy break into that house? Why did he steal that car? Why did he rob that bank? Why did he do that bad, thing to that young girl? But when you have to prove each and every element of a crime and prove those elements beyond a reasonable doubt, I can tell you as a criminal defense lawyer and as a prosecutor at local, state, and federal level, the military level, and then as a judge for 5 years, I never once saw a crime where element 5 was, and you must prove motive beyond a reasonable doubt. Motive is never an element of a crime, period. And so I don't think actually this is going to affect the fact-finding process at all at the lower court. What I think it will do is it will give the government and the defense and really the trial judge a way to think about the weight of a particular piece of evidence. It won't affect the admissibility. And let me be more specific. This isn't an evidence class, and I won't bore you all with evidence. I won't put on my law professor hat. But on Federal Rule of Evidence 401 is relevance. And evidence is only admitted if it's relevant, right? It has some probability to prove a fact in evidence more or less likely true. That's essentially the definition of relevance in non-lawyer lingo, right? And so if for example, let's talk about a visitor log, or let's talk about a text, or let's talk about a tweet from the President Trump. He tweets something out, go to the Hill and get your voices heard. He tweeted it. The question is, was he a candidate when he did it, or was he acting as the president? It clearly doesn't fall into the top category of absolute immunity, right? Because it's not a conclusive and preclusive power. So then it falls into the second category of presumptively immune unless it can be rebutted. Maybe the prosecution then will say, well, you know what? He was in the sentence before that and the tweets before that and that exact timestamp, he was talking as candidate Trump. He wasn't talking as President Trump. So we've overcome our presumption, and that piece of evidence is coming in. The judge says, defense, what do you have to say? Well, you know, Your Honor, yeah, he was talking as a candidate. Therefore, it comes in. Notice the word that never came in that discussion, motive. Why did he tweet that? Who cares? My point about motive is who cares? Now, I live here on earth too. Okay. So when I was arguing, you know, cases in front of juries about homicides, the $100,000 question is, why did he kill him? You don't have to answer that. Juries like to know, juries will speculate. And sometimes I would stand up in front of a jury and go, I have no idea why he killed this guy. And I don't have to prove it to you. So when the defense gets up here and says, I haven't proved motive, well, yeah, that's right, I haven't, because that's not my burden. And that is not in the charge sheet. Or drug dealer kills drug dealer. Well, I don't have to prove motive, but it's very clear he killed him because he wanted his turf. But here the court is stating the obvious. Motive is irrelevant, and motive is never an element of a crime. And so therefore, I don't think this has the bombshell feel to it when you understand that in the evidentiary context.
Thanks for that. And then next one, I wanted to quote Justice Sotomayor's defense or dissent and get your opinion on that. So
Sure.
At the end of it, she said, moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law will not provide a backstop. With fear for our democracy, I dissent. So do you believe that Justice Sotomayor does have a valid concern about presidents misusing official powers, or is this kind of hyping up that fear?
So let me dissect her sentence, and I'm going to have you read the first part. And when I go, that's the part I agree up until. Okay, so start reading it again.
All righty. Moving forward, however, all former presidents
Go, keep going.
Such immunity. If the occupant of that office
Will have
misuses
such immunity. That's correct. Yeah, but they've always had immunity. They've always had it. But keep going.
power for personal gain, the criminal law will not provide a backstop.
And that's the exact opposite of what the opinion said. The opinion said, number one, no presidents have immunity for personal acts, and presidents enjoy the presumption of immunity for executive acts that don't fall in the conclusive and preclusive category, but can be rebutted by the government. And so she's mischaracterizing, in my personal opinion, what the majority opinion held. And in fact, we know that's true. You know that's true, Wyatt, because again, the court didn't say it's over. Trump's a good guy. Forget it. He has blanket immunity. He can do whatever he wants. They sent the whole thing back to the lower court, except the bit about talks with the Justice Department. So I just respectfully suggest that that is internally inconsistent with what the majority held.
Mm-hmm. And then one of my last questions, I was kind of interested in seeing if this would in any way affect possible impeachment of a president, because it was this talking about the absolute immunity from federal prosecution, but with impeachment obviously starts in the House and the Senate votes on it. Do you believe that because it's a legislative role, does it even affect impeachment?
No, it doesn't affect impeachment, because remember, impeachment is not a criminal process. Impeachment is a political process. And in fact, Trump's attorneys made an argument, which was rejected by the court, that he can't be prosecuted unless he was first impeached. And the court swatted that away like a summer bug at a party. So that's not part of the opinion. And nor should it be. And furthermore, I just want to make sure that we are not attaching a bumper sticker label to this opinion, because it's much more nuanced, I think, and I hope I've conveyed that to you, than the headlines have led us to believe. This is not an opinion that held that presidents are absolutely immune for their actions. That's the third grader maybe understanding of it. This held something very different. This held that presidents have absolute immunity for their conclusive and preclusive powers completely. Those executive actions that aren't conclusive and preclusive, they can be prosecuted for if the government can overcome the presumption of immunity. It's a big category of stuff. And they have zero immunity for their personal acts. And so I'm not saying you're acting this way, Wyatt, but I'm just saying that we need to take a deep breath and understand what this opinion actually said.
Yeah. All righty. Thank you so much.
Great questions. Thank you.
Yeah, great questions to everybody. And thank you, Cully. That's why we wanted to have you on today, to just get to the bottom of what this opinion actually said, because just get past the headlines a little bit. You've been so great with that today. We want to take a moment and recognize our teachers and students who are watching today. We have D'Angela Hines with students watching from Emerald Coast Christian Academy. And then we have Claudia Scott, who's a teacher at Hamilton Heights Middle School in Indiana. And even though school's not in, Claudia teaches grades 5 through 8, and that ranges in 140 to 200 students per grade level. So Claudia, we're so glad you're with us today. We also want to thank our listeners in Las Vegas's KKVV 1060 AM. This program airs on Monday evenings at 6 p.m. Pacific in Las Vegas. So thank you to everyone listening in Las Vegas. So, Cully, we have a question from Julianne Smith that asks, where do you suggest we go to read the SCOTUS decision? Do you have a suggestion for a layman's version of this decision?
Yes. So there is a blog called SCOTUS blog. And not only do they have Amy Howe, Howe, is the head honcho over there. She does a great job. She has a whole stable of lawyers who are pointy-headed, constitutional, brilliant people who write about stuff. But they also summarize these opinions in layperson language in real time. So you can read, 2 or 3 paragraphs in non-lawyer speak about every single decision. The other many wonderful features of SCOTUS blog is they not only list the opinions that the court hands down, but they list a calendar on the right of listing when the opinions are coming out, when the justices go to conference to decide whether to take up a case, because of course they don't have to take up a case. It's called, it takes 4 justices to agree to take up a case, 4 out of the 9. Those are called conferences. And then it also lists the cases going back many, many terms, and it lists the cases that the court has already accepted for this fall. And remember that the court is in summer recess, and the court opens on the first Monday in October, right after the Red Mass, which takes place at St. Matthew's Cathedral here in Washington, because remember, the court system was run by the Catholic Church, and the Catholic Church vestments were red in October, and that's why it's called the Red Mass. So they bless the justices before they head off to the court. So SCOTUSblog.com is the place to get that.
Thank you. That's a great resource. We really appreciate it. And then both Susie Bliss and Julianne asked sort of the same question about next steps. Susie says, unfortunately, most people think this is a done deal. Who is the district court doing this work, and how do we follow it? And then Julianne says, what are the next steps for the lower court and the timing of it? And what do you believe the lower court should do regarding these issues left for the court to decide? So that's a lot of questions, but they're all sort of in the same vein as next steps.
Yeah. So federal district court judges are appointed by the president, confirmed by the Senate. We have a whole bunch here in Washington, D.C. Tanya Chutkin is the district court judge who has this case currently. And so she will now, because the case has been remanded back to her court, go through the process, like I said, slowly, methodically, sort through not only the contours of the opinion, and of course she'll ask for a briefing, which means a written document by the defense and the government about what charges, if any, automatically get knocked out. And I think the government will have to concede that the charges related to the discussions with DOJ are out, they're gone. And then whether any other charges are just out, and the defense will no doubt say, well, they're all gone. And then the government's going to go, no, and they'll fight over that. And then the ones that the judge says, well, I want to hear evidence on before I make my decision, she'll just call witnesses, and the government will have to overcome their presumption. And the defense may concede on certain things, saying, well, actually, this was a personal act. So that charge can stand. So this is going to take months. This is going to take a long time. And by the way, if Trump gets reelected, he can pardon himself, like any president could.
Right. And going back for a second, Cully, you'd mentioned the red mass.
Yeah.
And you said could you go over that one more time you said the courts were originally run by the Catholic Church, or what did you say about that?
Yeah. So because you've heard of canon law, and you remember before Henry VIII divorced his first wife because he tried to cajole Thomas More, his lawyer, his counselor, to bless his divorce. The Pope had sway over canon law, and so because there was a lot of connections between the court and the church, the Roman Catholic Church, there would be a mass on the Sunday before the first Monday of the High Court term. And the vestments, the cloth that the priests would wear during that part of the liturgical season were red. It was called the Red Mass. And so I used to serve in the Red Mass as a person who would help collect money and seat people. And it's here at St. Matthew's Cathedral in Washington, D.C., near Connecticut Avenue. And 2 or 3 of the justices show up for the Red Mass, a sort of tradition. So you can hobnob with the justices. You're not going to get anywhere near them, trust me. But you might be able to see them from 50 yards. And then the first Monday in October is the opening of the Supreme Court term.
Fascinating. Okay.
And you can look up the Red Mass. You can
Yeah.
find out about the long history. I don't want to give you the War and Peace version.
Yeah, no, thank you. And then Tracy asked,
That doesn't mean just so every separation of church and state. That doesn't mean that the Catholic Church has anything to say over the Supreme Court. I just want everybody to be really clear.
Zero.
Yeah.
Nothing.
Okay. I can just see the letters and emails coming from
Yeah,
that.
they have zero to do
Okay.
with it. No.
Okay. Yeah.
so Tracy writes, I've heard the judge in New York has delayed sentencing in one of President Trump's trials because of the Supreme Court decision. Is this true? And if so, why?
Yes, it's true. It's partly true because the defense asked for it and the government agreed to the delay. Typically, when both sides agree, the judge goes along with it. But also, there's a practical reason. They have to understand and evaluate and think through the impact of the Trump versus United States decision. Why? Because even though he was convicted of state law crimes, much of the evidence that was admitted in that New York City trial before Judge Mershon was stuff from Trump aides like Pope Hicks, like texts, like other things while he was the president. And so the defense is going to say this whole case needs to be dismissed. If you want to retry it, best of luck to you. Because Judge Mershon is now going to have to look back and go, well, these 87 of these 93, I don't know how many pieces of evidence were admitted. Of these 93 pieces of evidence that were admitted, 44 fall under presidential records, which the Supreme Court said you can't use. And so the judge would have to make, I think, the astounding conclusion that, well, the jury would have convicted anyway. I don't think any judge can do that.
Did they say in this opinion that you couldn't use presidential records, or was that a past opinion?
No, they said, and let me quote it, I know I have less than a minute. They said that testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. And that evidence was admitted at that trial. So the question is, does Mershon just dismiss the case and the government has the choice to retry it if they can?
Well, thank you.
Right.
We're getting very close to the top of the hour. It's been a fascinating discussion. And one of our listeners, Rick Maryberry, even wrote in and said, this was the first rational and sensible discussion I've heard or read on this topic. I understand so much more and have a sigh of relief that our country is not turning into a dictatorial power that will turn into a president running unabated. Thank you. So, Cully, thank you. And for your very thorough explanation of this decision and what to expect going forward. And we want to thank all our listeners for your great questions. We invite you to come back next week. We're going to be looking at another Supreme Court decision that just recently came out on the Securities and Exchange Commission, with the Supreme Court saying that tribunals may not be used as they have in the past to render judgments in certain cases before the Securities and Exchange Commission. And it can have a far-reaching effect on administrative law. So we encourage y'all all to join us next Tuesday at 2 Eastern. And anyone else want to give any parting words before we go?
Yes, it's Janine. Thank you, Cully Stimson. You're just my all-time fave. Thank you so much.
Nice to say that. Well, I hope everyone listening supports Constitution America. I think it's the best program for folks out there to learn about the Constitution, and I'm a huge supporter.
Thank you so much. Your
Yeah.
support means so much to us, and we appreciate all you do. Thank you. And thank you to the Heritage Foundation. Y'all do such great work. Thank you.
Welcome.
Okay.